are for determining taxable income from specific sources. What could the phrase specific sources mean? Andy Green only has income from within the United States, and Section 1.861-8 is the section of the regulations we were repeatedly told to use for determining taxable income from sources within the United States. In the first paragraph of the section, it again mentions specific sources, saying that the rules of the section apply in determining taxable income from specific sources and activities, which are described in other sections of the Code called operative sections. Section 871 is given as an example of an operative section. That section, as we saw before, states that non-resident aliens doing business in the U.S. shall be taxable under Section 1. The regulations direct us here for the complete list of operative sections which describe the specific sources and activities, income from which is taxable under Section 861. That list includes the foreign tax credit rules found in Section 901 and following. It includes the sections we saw before dealing with the domestic income of foreigners, and it includes certain rules relating to federal possessions, to foreign and international sales corporations, and to other foreign and international matters. But nowhere on the list of specific sources is anything which would include the income of a U.S. citizen who only has domestic income. The sections which determine the sources of income for purposes of the income tax only show income to be taxable when it comes from certain specific sources, which are all related to international and foreign commerce. The regulations reinforce the point another way. They say that a class of gross income consists of the items of income listed in Section 61, such as compensation for services, interest, rents, etc. The regulations then define statutory grouping of gross income to mean gross income from a specific source or activity, which must first be determined in order to arrive at taxable income from such a specific source or activity. So the items listed in Section 61 must come from a specific source or activity to be taxable. The regulations again point us to the list of specific sources in paragraph F1, which, as we have already seen, consists entirely of activities related to international and foreign commerce. These are the specific sources, income from which makes up the statutory groupings of gross income to which Section 1.861-8 is applicable. The section for determining taxable income from sources within the United States shows income to be taxable only when it derives from the specific sources and activities described in the various operative sections throughout subchapter N, which are listed together here in the regulations. The listed activities are all related to international and foreign commerce. Section 861 and its regulations are where we were sent to determine Andy's taxable income, and those sections do not show Andy's income to be taxable. Contrary to the misinformation spread by the IRS and the tax professionals, Andy's income is not taxable, according to the federal income tax statutes and regulations themselves. But how could this be? Surely it wasn't because Congress didn't want to tax Andy's income, so why didn't they? What was stopping them? As we saw before, the regulations generally define gross income to mean all income from whatever source derived, unless excluded by law. This last phrase has been almost universally misunderstood to mean that all income is taxable unless specifically exempted by some statute. But there is another type of law which can exempt income from taxation. According to the Supreme Court, it is elementary law that every statute is to be read in light of the Constitution, and that however broad and general its language, it cannot be interpreted as extending beyond the constitutional authority of the legislature writing the statute. The older regulations defining gross income began much as the current regulations do, stating that gross income means almost every type of income unless exempt from tax by law. But the older regulations elaborated on the concept. They said that certain types of income were exempted by statute, and went on to say that no other items are exempt from gross income except those items of income which are, under the Constitution, not taxable by the federal government. This was a clear admission that some income not specifically exempted by any statute was nonetheless exempted from taxation by the Constitution itself. The regulations back then defining net income, a phrase which would later become taxable income, reinforced the point, saying that neither income exempted by statute or by fundamental law, meaning the Constitution, are subject to the tax. This matches what the Supreme Court has said about the Constitution itself restricting the application of an otherwise broadly worded statute. This poses a problem for today's tax professionals, as they are unable to name any income which is not exempted by statute but which is exempted by the Constitution itself. While they may be able to name something constitutionally exempt, such as the income of state governments, such things are already exempted by the statutes, and this was already the case when these older regulations were written. But we cannot just guess at what is constitutionally taxable. The Secretary of the Treasury is the one authorized to write the regulations which tell how the statutes are to be interpreted. The older regulations answered the question about what is constitutionally taxable by saying that profits of citizens, residents, or domestic corporations derived from sales in foreign commerce must be included in their gross income. They also mentioned non-resident aliens and foreign corporations, and citizens and domestic corporations who receive income from within federal possessions, such as Puerto Rico. But no mention was made of citizens who receive all of their income from within the 50 states. This is a list of those types of commerce which the Secretary of the Treasury believed were, under the Constitution, taxable by the federal government. It matches subchapter N of the current code, which describes the types of commerce which Congress felt could be subject to a tax based on income from sources within or without the United States. It includes the domestic income of foreigners, certain foreign income of U.S. citizens, and certain rules regarding international sales corporations and rules about federal possessions. Anyone who doubts that this is an exclusive list of the types of activities which are taxable runs into several logical problems. First, these activities are not mentioned at all in the statute defining gross income, so why do the regulations mention them? If this is not an exclusive list of what is constitutionally taxable, why are these activities mentioned at all? And why would the regulations specifically say that citizens must include certain foreign income while never saying they must include their domestic income? Also, if this is not the answer to the question about what is constitutionally taxable, then the regulations never answer the question. Nothing else in these regulations even comes close to saying what is or is not constitutionally taxable. The regulations must give specifics. They must tell the public precisely what the law requires, and they did. But why would this be all that is constitutionally taxable? Why these activities, and why not the income of most Americans? The Constitution created a federal government of enumerated powers. The powers delegated by the Constitution to the federal government are few and defined. Article 1, Section 8 of the Constitution lists all of Congress's powers within the 50 states. In this particular case, the Supreme Court threw out the original gun-free school zone law, saying it was beyond the authority granted to Congress by the Constitution. The Constitution empowers Congress to write laws concerning things such as currency, bankruptcy, immigration, patents, military matters, and a few others. The 10th Amendment states that all powers not specifically granted to Congress belong to the state governments or to the people. Congress is granted the power to regulate commerce which crosses state lines and commerce with foreign countries. However, when it comes to matters happening